Hello, everyone, and welcome to the Legal Power Hour, where we jam 60 minutes of thought-provoking discussion into a 30-minute show designed to inform, awaken, and protect citizens. We are your co-hosts, Tom Scott and Sarah Nahidi, and today we're absolutely delighted to have a stalwart of the legal movement with us today here on our show. His name is Bill Scheidler from Washington State. And he's going to talk to us about his experiences in that state of Washington. So without further ado, we will get right into it. So Bill, if you would, could you kindly tell us about your role as chief activist? I know you're a chief activist for a website there trying to expose judicial corruption in Washington State. Can you tell us, our viewers, your education, your work, anything else that you'd like to discuss? I know you've told me in the past, but if you could elaborate on that for our viewers.
Yeah, how I became chief activist, and I've been using the term the reluctant activist, is because my background's chemistry, and when I retired from the profession, there was a program that was published by our Kitsap County government that was supposed to make available a constitutional program for retired people. It was basically to help them pay ever increasing property taxes. When I got the information packet, I recognized that the instructions were very difficult to understand. So I went to the actual laws that were cited as, the instruction packet uh, uh, implementing, and the laws were completely different. In other words, the laws were straightforward and easy to understand, but in the information packet, they substituted one word for another. They rearranged the phrases, and they basically invented their a new law. So I went back to the county and I said, look, you're claiming this information you're giving out quotes a law, and I said they're completely different. I said you need to, if you're going to claim it quotes a law, you need to quote the law and not make something up. And they refused to. They just brushed me off. So I went up the chain of command. I went up to the then there's a state agency that's supposed to oversee the county and how they implement this, and they basically gave the excuse they didn't have jurisdiction. I went to the attorney general, and same excuse. The attorney general doesn't have jurisdiction. I went to all my legislators and I went to the governor, and none of them had jurisdiction to tell this county official to accurately quote the law. So I was forced to look for a lawyer, and in my county, I couldn't find one. I'm in Port Orchard, which is about 2 hour commute to Seattle. Seattle, I had to go to Seattle to actually find a lawyer. And it took me a long time. And finally, I was invited over to a lawyer's office, and I explained to him, I showed him everything, and he agreed 100% with me. He said, yeah, this is completely unlawful. They're deceiving all the county retired people. And it's basically to keep the income, keep uh, taxes high so that they could collect more in revenue, tax revenue. So he agreed to take my case, and he was on my case for about 6 months. And when he filed a memorandum uh, uh, outlining all of the violations the county was engaged in, the county prosecutor threatened my lawyer with his bar license if he didn't withdraw from my case. Immediately withdrawn. This was 3 days before the trial, and and uh, and he sent me a letter saying if the county doesn't waive their their threat, he's off the case, and he in fact withdrew. So that left me with two problems. One, I didn't have a lawyer to fight the county, and I couldn't find a lawyer. So I filed a bar grievance that this scheme in which a lawyer's extorted from a person's case, is violates the rules of professional conduct. And the bar itself delegated back to me the task of, you have to get a judicial finding that this is improper before the bar would actually look at the grievance. So basically, the bar was delegating me the role that they should have to investigate and determine whether or not this is proper or not. So now I had a third problem. How am I going to get a judicial finding? How am I going to get a lawyer? And how am I going to fight the county? So I filed a lawsuit against the lawyer to try to get this judicial finding. And that all ended up in me being sanctioned by the judge $120,000 for doing exactly what was delegated to me to do. So that's how I got. That's when it occurred to me that either the entire system is really messed up, or I just happen to have a string of unfortunate circumstances that lined up against me. So what I did was publish some of this stuff on the web, and as soon as I published a couple of my stories and what was going on, I started getting emails, phone calls, and even letters from people who are saying, yeah, this isn't just happening to you. This is what we face here. And it came from all across the country. So that's sort of the whole background as how I became the reluctant activist. And now what I've done for the last 7 and 8 years is touch base with folks like you. And I said there was 3 problems. One was dealing with the county assessor. So I had to take that matter on pro se because I couldn't find a lawyer. Mine was extorted from me. And of course, to take that matter through, I always had to plead the case to another bar associate, whether he was on the federal bench or the state bench, it was still a bar associate. So that ended up in the Ninth Circuit, and they agreed with me that there is a problem, and they remanded the case. The problem is it was an unpublished decision, and it was kind of so loosely written that the case, even though it was remanded, it was immediately dismissed again by the same judge on the same grounds that he was reversed for in the first time. So anyway, that's kind of a long-winded story to sort of explain how I ended up as a reluctant activist. But these are the things that we're finding, and some of the issues that we're basing our arguments on, both in court and in appeals.
What do you think are some possible solutions to deal with the fact that we have attorneys disciplining and supposedly overseeing potentially unethical violations by other attorneys? I mean, what do you see as a solution for dealing with the issues that you've personally experienced and run into?
Well, when they're in charge, when attorneys in our state, to be an attorney, you have to be in a bar associate. So when we're speaking of judges or attorneys or prosecutors or in any decision-making office, we're talking about a bar associate. And I think there are a number of tools. One is an initiative process in which a citizen could actually write a law. And it's difficult because once a citizen writes the law, the tough part is you need 300,000 signatures in order to get that law on a general ballot. But that's one process. It's an expensive way of going, but it's really a way in which a citizen can force a law. And once the law is specific to address, this particular problem, and we get the number of signatures, then that is the new law. That becomes law if it's voted upon by the rest of the voters. But it's difficult. The other one is and this is what I'm finding, and I'm not a lawyer, I'm a chemist. My background is chemistry. But when I research some of these issues, um, I don't believe the arguments that have been presented really address the core problem. For example, I don't know. Let's just give this as an example. This judicial immunity. It's a common law. It's a doctrine of judicial immunity. A judge is immune, for any acts he takes as a judge. Well, that's a common law ruling, and it's interesting as how such a ruling actually evolved if there's a federal statute that says a judge cannot rule in a case in which he has an interest, any interest, or in which he might have a bias. So if we look at the judicial immunity doctrine, that was established by a judge ruling on a case and giving himself, or giving the judicial branch in which all judges have a direct interest, immunity. So the very notion that a judge sat on a case in which the outcome was going to be a judicial immunity holding seems to violate the very statute that should prevent him from sitting on a case in which he has that kind of an interest. So, so I think, and this is one of the things that I brought up in my first appeal to the Ninth Circuit. They sort of tap danced around it, but I think they're leaving it kind of. I think they wanted the lower circuit to address that in a way that hasn't really been addressed. So we have those kinds of, the immunity judicial immunity doctrine. It's like, oh well, that's how they voted, but that's how the judges decided the case, and they take it for just carte blanche. Yeah, we got to take it. But if you look at it and say, what is the law? How did they comply with the statute to disqualify themselves if the end result of that case was going to be an immunity doctrine for judges? It's clearly there's an argument that I'm making that whole doctrine is based in a violation of the law. So that brings me to the second point is a lot of the arguments really haven't, maybe, and I'm saying this because I haven't found any arguments that are based on that type of reasoning. And so I'm basically saying is if those arguments have never been made, maybe there's still a way to make an argument that'll carry weight to address these issues based on some of the twisted logic that was used to actually come up with, say, immunities. But even beyond the seeming logical inconsistencies of the immunity doctrine in Washington state, we actually have a constitutional provision that prohibits immunities. So that too has never really been addressed by any court, either a state or a federal court. So we have as what can we do? Well, we can do as a citizen, we could address this through initiatives. We could address this through getting good representatives elected. And I tried, to run for office, not expecting to be elected, but at least, putting my hat in the ring so I could have a platform to talk to people and explain some of the problems that I'm finding and others are finding and reasons for the problems. So running for office, making arguments that have never been made, issues of first impression, so that the courts have to really look at, what they're doing and address why there seems to be an inherent conflict in coming up with a judicial immunity if a judge is disqualified from sitting on a case in which the outcome would be judicial immunity. And
Do you think that abolishing judicial immunity and prosecutorial immunity could help with this issue?
I think, yeah, I mean, once you give a judge immunity, then it becomes a condition in which a judge could rule any way he wants, and then you have, and that then becomes judges judging what the judge did, which is, here again, if there's a federal statute that says a judge cannot sit on a case in which he has a potential for bias, or if it looks, or there is an argument of bias, or if he has a conflict, a fiduciary conflict, it's not discretionary. He's mandated to disqualify. It says a judge shall not. It's not may not. It says a judge shall not. So,
but I wonder what the reality actually is of a judge recusing himself and saying, hey, I cannot proceed over this case. I just don't think that happens very often, even though they are supposed to, per the rules that apply to the judges, that they have to, but I don't think that happens very often.
Well, yeah, and I agree, and that's absolutely true. And there's I mean, the whole area, it's like, what are the circumstances? If a person says, I want a jury trial, well, then right away, the judge can't be deciding facts. That's also in Washington State, it says a judge may not comment on the facts, but only declare the law. That's in our Constitution. So if a person demands a jury trial, he should be entitled to presenting his argument to a jury, and that would eliminate this notion where judges get to decide things. But if a litigant says, I waive a jury trial, well, then the litigants give over. They give the judge basically the right to do all of the things they're claiming they have a right to do. But that's only if a litigant waives a jury trial. So I think the first step is to back up and say, hey, we have our jury, that is the very institution in which the people, in the form of a jury, exercise their power, their political power, over all the branches of government and over all of the people, as far as what do the people expect of our institutions, and what do the people expect as to what's right and wrong. So, if we get back to what the Constitution says, at least, and I'm speaking in Washington State, because in Washington it says a jury is an inviolate right in both civil and criminal actions. So if it's an inviolate right and someone asks for a jury, a judge no longer has summary judgment authority. A judge has no longer authority to dismiss a case under some common law doctrine. It's all now in the hands of a jury. So I don't know. I mean, I don't know. See, I wasn't brought up in the law. I didn't study it. I don't know how all of these things got entrenched into the legal system. But as someone that sort of got forced into it, and I start reading the laws and what the words of the laws are, and looking at how the legal system is operating, it's we deviate it greatly from where we should be. So I don't know what I read some of your book. I'm still waiting for the signed copies, but
It's on its way.
But I mean, all of the problems too. What are your ideas?
Well, one thing, you kind of touched on this a couple of times in your conversation here, Bill, is this whole thing with common law. And to me, you've seen this as well as, I'm sure the other people who've contacted you have seen this. We have our legislators, which write our laws for us. And then we have the judicial system, which uses common law, which I considered basically they're bastardizing our statutes. You know what I mean? Our laws say one thing, and then the case law may or may not reflect that particular law. So they've basically divorced from the judges. So it kind of gives you, now you combine that with judicial and prosecutorial immunity, and you've got this toxic recipe for them to have carte blanche to do basically what they want. Really, my number one problem with common law per se is that it allows the system to completely rewrite the laws. I mean, forget about the overt legislating from the bench. I mean, which the judges, do quite frequently. I'm sure you've seen it too in your case. But besides the case law, which is basically they give themselves overt position to write their own laws, they actually do it covertly by breaking laws on top of that. So they have two stages of these violating these laws, right? You have the laws that are written, then you go to the first stage, which is okay, we have case law, which says, well, we really don't have to do what the law says. And then they have their openly violations of law. I've had judges commit criminal acts against me in civil cases, at the state level, the federal level. So it's like you, I was forced into it, but I'm seeing the same, we sing the same song. I don't think it's any different for any one of us victims of the system. But that's the problem I have, is the case law. I don't like case law.
Yeah, and in Washington State, and the reason I'm saying in Washington State is because if you and I have compared Washington's Constitution to like the constitutions of Florida and New York, and they're substantially different. Just one illustration on how different they can be. I think Florida statute says that it is, if it's all in the public's benefit, or if it's in the public welfare, or it's for the public good. Well, in Washington State, it says for individual rights. So the common law that is developed in Florida under the for the public good, whatever that might mean, shouldn't be applicable in Washington State, where the Constitution specifically says for individual rights. So what is good for the public might not be good for the individual, and what common law is established under Florida statute shouldn't be imported into Washington and used as the common law holding against when our constitutions are different. And also in statute, and I believe the statute embodies all of the concerns you said, because in Washington State it says the common law shall be the rule of decisions of all courts in this state, as long as that common law doesn't conflict with the U.S. Constitution and laws, the Washington Constitution and laws, and conflict with Washington's institutions and conditions of society. It's a 6-part test before common law can be used in a particular case. So, and I brought this up in the Ninth Circuit the first time I was there. I said, they use this common law holding of Iqbal Twombly, as far as your pleading didn't meet the Iqbal Twombly standard, whatever that is. And it's left, really up to a judge deciding what the Iqbal Twombly statute is. Well, Iqbal and Twombly are cases that have to do with a terrorist and the FBI or some security entity, agency of the federal government that's involved in security. So why should Iqbal be the rule of decision when it's, in my case, a citizen versus a Washington State agency that's misbehaving? So Iqbal should be a case law that should not apply. Furthermore, Twombly is between two, I believe it was two telecommunications corporations. Well, here too, communications corporations there isn't a fiduciary duty one communication corporation has to another, But in my case, the government's a fiduciary. It has a constitutional obligation to me. So why should, the case law developed by Iqbal Twombly affect, be applied in my case? And that was brought up to the ninth. Now, the only reason I'm a little bit optimistic is because if all of those arguments were held by the ninth, my case would have been upheld and not remanded. So the fact that the ninth ruled in my favor to remand the case, despite the defendants, and these are government officials, the defendants claiming they have immunity, that the pleading standards, blah, 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 and all this other stuff. If all of those were valid arguments, the case should never have been remanded. So anyway, so I still believe, and until I'm back in the ninth, so we'll see how that turns out. But I still believe that a lot of our problems remain our problems because, one, we don't go to the ninth. We don't take the issue far enough. We either throw up our hands at the trial level and say, we can't beat the system, or we don't really make the fundamental arguments that there's that these differences matter, and you can't take case law from one jurisdiction and apply it without doing the 6-part test as required in Washington state. So I agree with you. The way they use case law, I think it's criminal right from the get-go, because in Washington, they have to justify the case law. If they don't do it, why should it be accepted as valid in Washington? So, but these are the arguments I'll be making going forward. So we'll see what happens. I don't know. What do you think?
Yeah. Well, yeah, the whole thing, I wish you the best of luck. And it does sound like, based on what you said, that the Ninth Circuit does have an interest, but the problem is this whole rearranging of the furniture is what the system does. They give themselves too many avenues to rearrange the furniture just the way they like, whether it's case law or just breaking the laws outright, or these, as you pointed out in the beginning of the conversation, the lack of the system to identify their own responsibility to keep their own people in line, because there's no competition in the system. We have one legal system. Of course, we write about this in the book. But this whole, I like use the term they rearrange the furniture, because that's basically what they do. If they don't like the way the field looks, they just change it as at will or ad hoc as they deem necessary, and it creates unnecessary corruption and victims of the system. Is there anything you'd like to add, Sarah? I mean, we're pretty much out of time, but it's always great talking to Bill. Is there anything you'd like to add?
I think the bigger problem and a bigger issue at large that we have in this country is that the government is way too big, and they're way too involved in every aspect of our life. And so it's just a David versus Goliath situation, where you've got this monstrosity of government with way too many rules, way too many laws, way too many entities. And I think that the bigger problem is that we need to cut down on how big the government is. The more people, the more cooks that are in the kitchen, the more that there's not going to be consistency in how things are handled. And it's just rife for corruption. The more people you have in power, the more corruption that's going to exist. So I think we need to look at how to downsize our government at the national level and at the state and local level.
Yeah, and I thought about that too, and my thought was my case that's now going to the Ninth Circuit. I'm suing my legislators because their blind eye to the corruption within the judicial branch is a breach of their constitutional powers. And again, there's constitutional provisions in Washington that says the legislator may remove a judge simply by a vote of the legislature. you know, but in order to get a vote by the legislature, your legislators have to propose what's called it's like a bill, but I forgot what it's called. But
do legislators in your state have immunity, or can somebody actually sue a legislator?
Well, the statute says a person can sue any elected official for their performance or non-performance of a duty. Any elected official. There's no immunities allowed in Washington state. There's no statutes that bestow immunities in Washington state. The Constitution prohibits immunities. So these are the arguments I'm going to be making, because that's one of the reasons my case was booted, is because a judge gave the legislators immunity despite the statute, and he never addressed the statute. You know, it's like Tom says, they just ignore what they don't want to address, and then they go ahead and rule the way they want to rule. But you know, so you know, the argument is we need a jury to decide what these government officials can and cannot do. And by a jury, if we bring back our right to plead the case to a jury, then the size of government may actually be regulated by the verdicts juries start handing down. Just let's, you know, imagine that if a jury agreed with me that, yeah, these legislators should have submitted all of the evidence to the whole body for a vote to see whether or not this judge that I'm complaining about violated the laws that apply to judges. And if the jury would agree with me, then those legislators have a new obligation, and that is to address corruption, not to turn a blind eye to it, but to address it, because they're going to be held financially liable for the damages if they don't do it. So, you know, I agree. The government's way too big, but I think if we get back to, you know, the letter of the law and doing what the law says and allowing the people their right to make the decisions about how government behaves, you know, a lot of it might not stop the size of government, but at least it might start cleaning up the corruption. And there was one other thing I wanted to bring on. I don't know if we have enough time, but
Sure.
One of the things that we've started to do here in Washington is we look for cases that are already in the courts, and then we file either motions to intervene on these specific issues. And if it gets to appeal, there's a couple of lawyers here who agree to to file friend of the court briefs in those appeals. So we have, you know, I have, I don't know how many motions to intervene filed, and I'm an intervener in a couple of cases in the Ninth Circuit, and I have, you know, as far as friend of court briefs. So we're starting to pile on whatever we see a case that's in court, we get everybody to file friend of court briefs and try to intervene. So that sort of, you know, if anything, it's starting to let the appellate courts know that we're seeing what's going on and we're upset about it. So I don't know if that's, another viable avenue, but all of these things that empower people, the jury, the initiative process, running for office, and taking the case as far up as you can. I think these are all of the tools we need to use to help, try to address some of this stuff. Otherwise, it's out of control.
Yeah, and one quick thing I wanted to say was that I think people's apathy in this country is a major issue as to why these things kind of keep steamrolling forward and the problem gets worse. Is like you said, Bill, we need to get people engaged, involved. We need to get them to care and to use their civic duty and their civic right and responsibility, I think, to participate in government, participate in the process, get their voices heard. And that starts with, getting out and voting at the local, state, national levels, and like you said, exercising your right to a jury trial. I don't think people do that often enough. Most of the cases I've been a part of, it's just the judge deciding. So, I mean, if we give power to the people and we get them involved, I think that's one way to address the issues that we have with the system.
Yeah, I agree. And that's our argument is, you know, we want jury trials, and that's why we intervene. It's like this case was supposed to be heard by the people in the form of a jury. And, you know, those are the messages we're trying to send to the appellate courts. So, you know, that's the bottom line, Sarah, is the people have to take control, or the people have to have their rightful position in the jury box so they can exercise their power. And well, I mean, that's how I'm the reluctant activist, is because those are the issues I'm fighting for, and hoping that, you know, in some way, if we have a little success, it might go help some of the problems we all face.
Bill, I gotta say, yeah, you're a reluctant activist, but all those people of your state of Washington should be thanking you. You're doing what a lot of people should be doing and getting tuned in. We thank you for that. I've had a great time talking with you. I know Sarah has. We're gonna wrap the show, and I think we're gonna actually ask you to come back again because it's so great talking to you. It's just informative. It's enlightening, and it's a spirited intellectual conversation. I think our viewers are really going to enjoy learning about what's going on in your state. So thank you so much, Bill, for being on our show.
Thank you. I enjoyed it, and I appreciate all of the work you guys are doing. It's great, and I look forward to my signed copy of your book.
Yeah, it's on its way, like Sarah said. Is it one thing I want to ask? What is the website? We're going to put a link below this video, but what is the website that our viewers can click on and support you financially if they decide to purchase our book and get information from your site? What is that site one more time?
It's corruptwash.com. So it's corruptwash.com. Corrupt Wash.
Okay.
Okay.
Okay. So
Thank you, Bill, for being on our show again.
Thank you, Sarah.
And just in closing, I'd like to say that to all our viewers, to catch our show fresh every first Monday of the month at 7 p.m. Eastern Time, or view it any time afterward right here on our YouTube channel. Be sure to subscribe to our blog for informative monthly posts at www.stloyf.com/blog. And if you really want to protect yourself to the fullest extent possible against our wildly corrupt legal system, pick up a copy of our book, Stack the Legal Odds in Your Favor. Please use the link provided at the bottom of this page, this video, to our partner, Bill Scheidler at Corrupt Washington, so that you can financially support them in their tremendous efforts as well. Again, Bill, thank you so much for being on our show, and I look forward to having you again.
Thank you.
Thank you, Bill.
Thank you.
Bye.
Bye.
Bye.